because the male student, the goons, have struck. So what happened was that they continued like that. I would report. I had reports of them. Then the elections were held, and the elections were shambolic. The students were very, very unruly. So I knew that these young men were engaged. And so what I did was, through the processes, I wondered, were they going to be netted? And when they presented the list in Senate of who the students were, these students were not there. And so I actually told my boss, it is either these students are there or I am not the dean. Because you see, that also denies you the authority if people can get away with whatever they do. They went through disciplinary proceedings, and I must say I was sad myself at that process, because these were fourth-year students in the last 2 weeks, and I had not actually realized that if you put the university in an odious position, the only remedy, or the only thing that can be done to you is expulsion. And the students were expelled. So I actually later came back and have actually worked a lot with the university administrators trying to get these students back. And I do hope that they learned their lesson. It was a very painful lesson for me as a mother. When mothers come and lie on the seat in the office waiting for you to deal with them, and then you realize that these are very poor students, some of them. So that was one of the difficult things that I had to do.
Okay. So, Prof, tell the Commission one or two things you have done, innovative things that have brought impact, and which can be attributed to you as a leader because of your leadership excellence. And I know maybe you have talked about some of them, but just point out one or two that you feel, if it were not for my leadership as Professor Mbote, this would not have happened.
Okay, I'll give you two. One is the establishment of Strathmore Law School. And let me say that for me, establishing Strathmore Law School was a way of getting the giant in Nairobi to move, because I had been a leader there as chair of department, and I had vied for dean and not succeeded. And so when I was restless, and when the opportunity came for me to go and start a new law school, I felt like they had given me a blank sheet. Of course, I worked with very many people, but Strathmore gave me so much room and so much latitude that enabled me to start a school that I think is excellent. And the spin-off is that my school, my alma mater, University of Nairobi, woke up, because they realized that now there was competition in town. It was no longer enough to say we are old and we are gold. The new ones can actually, they can actually threaten your continuation. The second one I'll give is from this COVID-19 situation. In conjunction with the African Development Bank and colleagues at the school, we were tasked to train Kenyan and Ugandan lawyers on integrating environmental issues in oil and gas contracts. And we talked, in fact, the officials from the African Development Bank even came to visit us at the university. We were going to have it at the university towers. The students were, the lawyers were going to stay at the Norfolk. And we had the last meeting at the end of February. Then COVID struck. When COVID struck, I had three options as the leader. One was to call off the training and then say we will do it another time. The second one was to wait out COVID, because now there were the travel bans. But I took the third one, which was to innovate. And I spoke to my younger colleagues, and we agreed that we were going to have training for Ugandan and Kenyan lawyers virtually. And so what we did was to get another group of young Kenyans. Kenyans, we have extremely talented Kenyans. I just told them this is what we want, a bespoke training platform which would be used simultaneously in Uganda and in Kenya, and also would be accessible to the bank officials in Abidjan. And they did that, and we were able in June last year to host a 4-week program. What we had to do, of course, is to reduce the number of participants, because when you go virtual, then to engage people one-on-one, you need to have less students. And it went very well. Everything was done virtually. Even the certification was done using the bespoke system we had developed.
Thank you very much. I'll now request the acting CJ to ask you further questions.
Thank you. Professor Senior Counsel, you come into an institution that has been doing something called transformation, more specifically since 2011. Okay, please explain to us what prepares you for that transformation, whether you know what it is we want to transform ourselves from to, and what tools you would use in that transformation, or has that transformation in fact done time, and should we now go to something else? That will be my first question.
Thank you very much. It is interesting because I was in the first team who worked on the Judicial Transformation Framework, and you know we were coming from the previous constitutional dispensation where there were very many problems in the judiciary. I must say that I have followed what happened with the Judicial Transformation Framework. I've also followed what you lead, which is the Sustaining Judicial Transformation. And I can see a lot of steps have been made. I think we were talking then about a lot of backlog. We were talking about an under-resourced institution. We were talking about not integrating ICT across different spaces. I think, if I remember right, there was also discussions about accountability, the whole question of performance management, because this had become part of the public service with the NAC government in 2003. And I think for the judiciary, this remained something that was being talked about. And I would say that a lot has been done. A lot has happened since then. You know, even this Judicial Service Commission was not this kind of Judicial Service Commission. It was a different kind. And so a lot of things have happened. So you've asked me whether the transformation has done its time. And maybe I'm going to be a little controversial. I will say you can't be transforming for 10 years. It is too long. I think you have to stop and ask yourself, what have we done and what haven't we done? And in coming to this space, I come again looking at what has been done, but looking also asking ourselves, how are we doing? Because if you don't look at where you're coming from, you could actually go back there without knowing. My analogy, again, as a mother, is of a child who is 10. This is a judiciary under the 2010 Constitution. It is 10 years. A 10-year-old child is heading to adolescence. Adolescence can be very turbulent years, and those are the years that determine whether the child becomes a well-adjusted teenager or a maladjusted teenager. And it would be good to take stock and to begin to look at what changes have worked, how do we make that change stick?
Let us, Professor Senior Counsel, redirect our mind to this aspect. Okay, we'll be doing this for that period. Do you know the successes we have made? Professor Senior Counsel, I just heard you say that our initial problems were backlog, under resourced. Those were your words?
Yeah.
And of course, accountability. I have no issues with accountability. I would like you, with your own statement, to tell us whether then we actually need to move to the next level. And for you to fully answer that concern, do you know what our management culture has been? And do you know what it has contributed to being where we are at today?
I would be lying if I said I know exactly your management culture, because if you're not wearing the shoes, it is difficult to know how the culture works. I can only talk about it as an outsider and as a person who's been observing what has been happening. I think a lot of, I hope I didn't come out as saying that transformation didn't achieve anything, because the performance management and measurement understandings have actually movement towards some of the things that needed to be dealt with, but also the whole issue of active case management using the daily court returns. That has also helped, because you know, when a judge or judicial officer is now asked to account for how they've been using their time. I only know the judiciary before 2010, because I did very incisive research on it. This one I have interacted with, but a lot at a distance. And you see, when I would go to, I served for 3 years as the rapporteur of the Judicial Colloquia, and I have not served since 2011. So I really do not have that inning on what has happened.
Thank you. There is such a thing as looking into the inside from the outside, and since you are involved in JTF, and you have said one or two things about SJT, I would like you to address this concern. The PMMUs, the performance contracting that we do here, we don't call it contracting. I want you to tell us what it is we do there. Is that an achievement? Has it actually changed anything? Has it interfered with the judicial independence of judicial officers? Is it a matter that goes to accountability? And as you answer that, Professor Senior Counsel, I want you to relate it to a statement you made earlier and said, when you failed in your attempt to be dean, you became restless and therefore went to Strathmore, and now you're back at UON. Could you relate that to transformation? Then we will move from that topic.
I understand the question to be how the steps that have been taken in the judiciary have impacted on the working of the judiciary. And I think you're taking this from the core of what the judiciary is about, the fact that you need to have an independent judiciary. And therefore, even as we talk about the performance management and measurement understandings, it is important to still bear in mind the importance of judicial independence, both for individual judges, but also for the institution. And I think the fact that there are different levels that have been established, especially under the acts that were passed after 2010, and also under the SJT and JTF, there are different levels of accountability. And I would say that these things go to the heart of independence. You can't look at independence without looking at accountability. And I think for the judiciary, because it is a counter-majoritarian institution, the judges are not voted for, it is important for the judiciary to actually show how accountable it is to the Kenyan. Why should Kenyans invest in the judiciary? And I think the way that is demonstrated is through what we put in place for accountability, and that can be internal or external, and PMMUs and other mechanisms are the internal ones. But there is also something I shouldn't fail to talk about, the code of conduct. Because you see, with a code of conduct that judges are aware of, then you know what are the permissible and not permissible actions.
As we leave that topic, Senior Counsel Professor, would you like to say something about your being restless?
I was young and restless then. I was in my 40s. I am now headed to 60. You know, there is something that comes with growing old, that you begin to see what it is that you need to do. If I was to make the decision of starting a new law school, I would do the same. And actually, even in leaving, though I said I was restless, I was within my rights to leave. You can take unpaid leave from the university and go and do something. What I did was unusual. Starting competition was not usual. So, Chief Justice, I have become a lot more less restless.
I hear you. In fact, the reason I ask is because of the step you took next, which was to be very successful at starting the law school at Strathmore, waking up the giant that was the UN law school, and then going back to the UN. Why?
Why did I go back?
Yes, yes. You have gotten to Strathmore. You're successful at Strathmore. Well, then go back. And how did you go back?
You know, I live by two mantras. One is Franz Kafka's mantra that paths are made by walking. So there doesn't have to be a road for me to take it. And when I went to Strathmore, I talked a lot to my younger colleagues, and I was telling them, you know, build the field, the players will come. But I also live by another mantra, which is by Woodrow Wilson, that we are not here merely to make money. We are here to make a difference. And when I started Strathmore, Strathmore is a small school. And I felt that there was a lot more that I could do at the University of Nairobi. Also, because it was a private school, the kind of students I'd meet there are not like the kind of students that I had met at the University of Nairobi, who are actually from all corners of the world. You know, people who came to Nairobi for the first time. And so to make a difference, I thought that going back to the University of Nairobi was it. But I still mentor Stanford scholars. When they call on me, I go to them. And it's not just Stanford, I mean Strathmore. It's also other schools.
All right. Thank you, Professor, Senior Counsel. Let's go to my next assigned area of discussion. Senior Counsel, when you come here, you become the president of the Supreme Court. We'll discuss that a little later. For now, I want us to discuss the chair of the Judicial Service Commission. What do you see as your roles there, and what would be the first thing you would fix once you get to the chair, Judicial Service Commission?
As chair of Judicial Service Commission, I think there is something that I have noted as both as a scholar and also as a Kenyan. And I think this is the fact that the Judicial Service Commission is very underfunded, and they are responsible for judicial training. As looking at the budget, and I think it is the total budget, if I'm not wrong, is $500 million. But the needs of training are a lot. I would actually bring in training, and I know that we are operating in a very constrained resource space. But as a Chief Justice and the Chair of the Judicial Service Commission, I would leverage networks. Like, you know, I'm coming from a school, so my colleagues should be able to teach judicial officers, those who don't go to court, without pay. And I also have networks around the world. I would be able to leverage those to bring up the teaching.
What is the common date of the Judicial Service Commission?
They are the employer of the judicial officers. That's what I think they are.
All right. And then your leadership, the Chief Justice of the Republic of Kenya, okay? And you have all these many stakeholders. I want us to deal with the internal stakeholders. What do you do there, and how do you ensure that you are successful?
You know, if you get into an institution and you're not accepted by the stakeholders, then you're going to not succeed. And I think even though I would have my ideas about what I bring into the judiciary, I would actually want to understand the culture that is in the judiciary. And one of the things I would actually do, I mean, I would like to work with a serving judicial officer, I say my chief of staff, because they will guide me through the hoops. Because if you get an outsider and you're an outsider, you really don't know what's happening within the institution. I've found out as a leader, there is nothing like knowing the pulse of your organization. And I would aspire to know the pulse of my organization.
So you would go for a chief of staff that was internal. I hear that. Let's go to the next role of the CJ. Now, that Chief Justice is of necessity the chair of NCAJ. Kenya law is the link between the judiciary, he, she, I mean, we know what he means in the Constitution, is the link between the judiciary and the other two arms of government, amongst many other roles. I'm leaving the role of Chief Justice as President because I want us to discuss that at a bit of length. So please tell us, what prepares you for the balancing act that of necessity is required to be a successful Chief Justice, to be a successful Chair JSC, successful Chair NCAJ, Kenya law, and the link between ourselves, the other arms of government, and the world at large? With that answer, we shall then go to something else.
Okay. What prepares me to serve as chair? I think I did say that I have served as chair of many boards, Water Services Regulatory Board, Kenya School of Law, And I was actually also a member of the National Council for Law Reporting as Dean of the School of Law, University of Nairobi. And so I could see and I observed the way in which law reporting is actually such a critical aspect of the judiciary that the Chief Justice was able to guide what is happening. So in essence, the chairing, I have experience doing that. I think as Chief Justice, being Dean, I was also the intellectual and administrative head of my institution. And you see, if you're a dean of very senior professors and you don't command the respect through the work that you do, then you see they won't respect you. And then when it came to administration, I needed to be the person between the school and the main university, because we are only a small unit. There is a college and then there is the main administration. So I would say that I developed ways of navigating those relationships. With the executive and other arms of government, I have worked with different arms of government, and of course not as Chief Justice. And I think diplomacy and negotiation are ways in which one could actually work with these institutions. I don't know whether I'm answering your question, but Chief Justice, because you are my senior in school, if there is anything I don't know and you're here, I will learn from you.
Thank you, Professor Senior Counsel. And now you are Senior Counsel, I am not. Let's go to the other area that is my leading area. Please tell us the principle in Marbury and Madison, and tell us how it impacted, if at all it did, the 2010 Constitution, what it does to constitutional democracy, what it does to the judiciary when it relates to other state organs, and please cite, if you may, any recent cases that derive from that principle.
Thank you very much. It's a long time since I read Marbury versus Madison, so I would say that I haven't interacted with the ratio decidendi, but in terms of constitutional democracy, I remember vaguely about the separation of powers. And in essence, what the 2010 Constitution did was to make the judiciary a lot more independent. I think in previous constitutional dispensations, the judiciary was subservient. It was almost subservient to, especially the executive. If you look at the way in which judicial staff were hired, so I would say that it has helped clarify the relationships. In terms, the case that comes to my mind is actually a case that is alive in court, that I would not want to talk about.
No,
here.
you wouldn't. You would not do that, at least not rightly. I was talking about already decided cases, but let's leave that for a minute and deal with the scope of judicial review. Do you want to say anything about the scope?
Yes, I'd like to say something. I think judicial review before was really based on common law, and I think the Article 47 constitutional provision on fair administrative action has, first of all, constitutionalized judicial review, but also expanded the scope because fair administrative action is required of not just state organs, but also non-state organs.
Please listen to this. This one I've written out because I want us to help the Commission to arrive at the right decision, and two, to help the court that you are coming to be president of. Okay? Some have indicted the Supreme Court, and particularly its position on the interpretation of the Constitution. There's been quite a bit of indictment out there. For you to answer that question, please tell us what the stated objectives in regard to constitutional interpretation there are for the Supreme Court, and how you think that, what techniques you think ought to be applied, and as this current Supreme Court done that, ought to be applied, or what you would yourself require of the rest of the 6 of us to apply to coherently achieve the objectives of the court as regards interpretation and to serve the people of Kenya who pay our salaries.
Okay. The Supreme Court, you say, has been indicted. I think the indictment sometimes is unfair because this is a young court, and as a new court, as you get things put in place, there are different things that need to be refined over time. I think if you look at, there are things that the Supreme Court has guided and guided well. If you look at the advisory opinion in the National Land Commission, it actually quelled the differences between the Ministry of Lands and the National Land Commission because they were in the papers every day. And I think also, to give a second example, when you look at the digital migration, you know they forced the action of digital migration. So I think in that way they have moved us ahead. So in terms of exercising jurisdiction as a court and what principles guide, I think Article 259 of the Constitution talks about interpreting the Constitution with the values, the principles that are in the Constitution to ensure respect for human rights, respect for fundamental rights, good governance. And I also like the statement that the Constitution is always speaking. So when you are a Supreme Court judge and the Constitution is always speaking, then it means that you have a very big responsibility to ensure that how it speaks is going to guide and move jurisprudence forward. Yeah, jurisprudence forward. I think this whole issue of whether the Supreme Court, what kinds of techniques it can use, it has begun to use them. You know, when it decides what is a matter of public interest that should be admitted into the court. Granted, there may have been opening up of issues that should not have been opened up, but when you look, all the time you are talking about good faith, that they acted in good faith. So it is not if anything happened, they were seeking to abide by the principle that you must avail justice.
All right. Thank you, Professor. Let's go to, so as to finish on that topic. We are required by the Supreme Court and the judiciary at large is required by our current strategic plan and by, to a great extent, the Constitution itself, to develop something called Indigenous jurisprudence. Please tell us what that is, and tell us what you have found to be non-Indigenous jurisprudence from the court. And as you answer that question, because that is the last one I ask on that area before my next final questions under the court, there is something around this area called hierarchy. It is a statutory requirement. Tell us what that is, tell us its challenges, and tell us the opportunities it creates.
I think when the 2010 Constitution was passed, the interest and importance of ensuring indigenous jurisprudence was speaking about decolonizing our legal system. And we were at a place where we were deferring a lot to authorities, and also even definition of terms from outside, which probably did not make a lot of sense to the local people. I remember in the early days of the judiciary, it was being talked about as Wanjiko. And you see, if we are talking about Wanjiko, there is need to make the jurisprudence that is coming out there address Wanjiko's issues. And I could go on a lot on that, but if
right.
that satisfies you.
Yes,
but
does.
Hierarchy, you know, hierarchy, you know, when you talked about hierarchy, what came to my mind was the hierarchy in the legal profession, the hierarchy in the courts, but hierarchy of laws. I think that's what you're talking about.
Both.
So the hierarchy of laws, you know, we have a very uncomfortable situation where, because of introduction of British law, a lot of our local laws were actually muted, and many of them really were not given an opportunity to develop. So when you talk about hierarchy, and then we say that we had under the Judicature Act the whole question of what is repugnant to justice and morality. I mean, for me, and I think I have written on this, whose justice, whose morality? So as we talk about hierarchy, and when we look at different issues, if we are not careful, it is likely that you can actually have a justice that is removed from the people, because the Constitution is the premier. It's actually it's the top it's the top legal norm. But under the Constitution, you know, there is already there is a, what shall I call it? There is a contradiction or a paradox, because the Constitution admits other laws as long as they abide with the constitutional provisions. And this is not a very easy distillation to make.
Thank you, Professor. Let's get to the court in which you have exclusive jurisdiction. And it is the Supreme Court, and you find when you arrive in June that you have 6 judges below you. In that time, you will no longer be my schoolmate, you will no longer be my lecturer, you will be the first, which is something you mentioned earlier, among equals. Some of those judges started the court in 2011, the rest of them have been there a minimum of 5 years now, and so surely they have something you don't have. Please tell me how you would deal with that. And at the end of your answer, please tell me something about building collegiality and what collegiality in truth is. And finally, on the same issue, because this is judgment making, you said at the university the people you called goons, I don't know whether they were university students or externals, but those goons led to some people being expelled at your instigation. Shortly thereafter, you came back and said, pleaded for them to be readmitted. Please tell us what that does to judgment making. And that would be the last question in that area.
Okay. I recognize that a lot of the people who are serving on the Supreme Court have a lot of experience. I am not the kind of person who comes in that because I am the Chief Justice, then my word is final. So there is going to be a lot of discussions as we make decisions, and there's going to be a lot of, I think, just encouraging people to openly air what their views are, which goes to the issue of collegiality. You know, collegiality is something that you can't force through law. So it is very important, and I hope it happens at the Supreme Court, that you have bonding sessions where people are able to know what is it that makes the other person, what makes the other person tick, and why do they behave the way they do. You know, collegiality is about companionship, is about empathy with the other person's views, but at the end of the day, a decision has to be made. So if a decision is being made that is against what a person has said, then I think the issue that comes against collegiality is civility. That whatever, even if you disagree, you do it in a way that does not dehumanize or make the other person feel that they are lesser than yourself. I think a way of building this is also encouraging the judges of the Supreme Court to exercise their mind and use their pen. I think it is, when you work in groups, there will always be a dominant person. And I do know that I can be a dominant person. So that I'm very aware of. I let other people do what they have to do, and I bring my issue along others to avoid being dictatorial, and to avoid asking people, or doing things that have no collective agreement. The other one that
The goons
and
judgment making.
The goons and judgment making. You know, thankfully, the rules of the university have changed, so probably nobody will have to sit on that kind of moral issue. But I think the Supreme Court decision binds all courts, but it does not bind the Supreme Court. And you know, I'm using this in a very loose sense because the Supreme Court cannot sit on appeal on its own decisions, and that is going to bind me should I succeed in becoming the Chief Justice. But on the other hand, even should there be need to change, that change is actually in exceptional circumstances. So what I'd say is the goon situation is a simple situation compared to what you face in the Supreme Court.
Finally, that court as original jurisdiction in at least 3 instances. What are the 3 instances where the court of which you would be president that has original jurisdiction? How is it exercised? And because that's a wide question, I will forego the next 2 questions I would have asked about the court.
The court has original jurisdiction in presidential election petitions. It also has jurisdiction in appeals by judges who have gone through the tribunal process. If they should want to appeal, that's the only place they can appeal. And the court also has jurisdiction on issues of declaration of state of emergency. I think it has exercised 2, the one on presidential election petitions, because we have had 2 cycles of elections under the Constitution, and there has been petitions. Actually, we've had 3 because the issue of judges, they also have had occasion to look at the decision of a tribunal. And I was actually very happy because the Supreme Court upheld the tribunal decision, and I was a member of that tribunal.
In the presidential election petition, what should bar, if anything, the court from arriving at the decision that the evidence presents?
You know, because I have not sat in decision, I haven't worn that shoe, so I don't know what would make the court come to a decision departing from the evidence. But I'd say this: when you sit as a judicial officer, you know your personal values, your personal inclinations should not be what guide you in making greatest battles are not fought in the mind, they are in the deepest recesses.
Professor Senior Counsel, would there be a situation where a decision could be made outside the evidence?
I don't think so.
And I thank you, and thank you, Chair.
Thank you very much. I'll now request Honorable Judge Wasame to continue with the technical questions.
Thank you very much, Chair. Professor, let's start having an honest, frank, and candid discussion. And one of the first things you mentioned is that you are not seeking employment, but you want to make a difference. Of course, you are an intellectual, but you are not a jurist. You are not a, you don't have that jurisprudential skills, but you are an intellectual. What makes you the most formidable candidate to fix the problems, first in the Supreme Court and secondly in the judiciary?
I think I was just thinking in my mind, what does the term jurist mean? And it's not coming to me. So I'll check later. But I haven't worked in the judiciary, that is what you're saying. And because I haven't worked in the judiciary, what makes me think that I am the best person. I think skills that we get in different places are transferable. And when you talk about decision making, because you're not making decisions alone, I mean the Supreme Court has other judges. And also in sitting and pouring through the into the Supreme Court.
Again, you are joining a court that is restless in jurisdiction and law insatisfaction. How do you intend to solve that?
I think that we are both restless means we are well aligned, because then there's going to be healthy tension. And the healthy tension, I think, is in, like I was, when I was responding to the Chief Justice's question, I said that it is going to be important to encourage members of the Supreme Court to use their individual minds and pens, even as we get, before we get to discussing the issue, so that we are able to move the jurisprudence of the court to the next level.
Okay, I will read.
You cannot have the reason that you're talking about appellate jurisdiction of the Supreme Court is that there is distillation, and you don't want it reopening things that have already been discussed by courts below.
So how do you intend to solve this problem of the Supreme Court, which I call restless jurisdiction, now saying they won't even gone beyond the minds of the framers of the Constitution in getting or in acquiring jurisdiction? How do you intend to solve as the president of that court?
I think one of the things we could do is to have a reflection. You know, I've been talking about the 10 years. I think that reflection is also going to cover those kinds of issues and how those issues affect the perception of the judiciary and of the Supreme Court by the common person.
Okay, let's go to the FIDA 2011 case, which you remember. What was the ratio in that case? And has the situation changed?
You know, there have been many FIDA cases. Is this one on the appointment of
Yes.
Supreme Court judges?
Yes.
I think the court was struggling with a very new principle of, I think it's Article 27(8), when you're talking about not more than 2/3 members of the same gender. And I think the decision was that you need not go to mathematical prescriptions, that you need to ensure that the court has the face of Kenya, has gender, and therefore is representative of Kenyans. I don't want to pronounce myself on this, because should I become the Chief Justice and it comes in, I'm sure that that is where people are going to hit me from, because they'll say you've already. Of course, I've written about it, but I don't want to express myself here on that issue.
In terms of appointive positions, is it your view that when we are considering the 2/3, 1/3 gender rule, we direct our mind to the specific court or to the judiciary as a whole? Because it talks about appointive.
You know, that is an argument, Honorable Commissioner, that people have been pushing, that you look at the whole. But I think it talks about each specific court, because if you look at the whole court, you may get to a situation where, and that's likely to happen for the underrepresented and marginalized groups, where they make the bulk of the lower echelons, but they never make it to the higher echelons. So I would say it is for each level.
Okay, now let's come to the value and place of advisory opinion and whether it is binding and enforceable.
I think when people come to ask for advisory opinions, it is because they are dealing with tractable issues. And many of the ones that have come have actually been followed to the letter. So I would say it is, they've been followed not to the letter. So if there is a failure, like with the gender one, where there was the provision that I think the court held that there should be a particular mechanism by a particular date, and that date has eluded us. So I think you ask for an advisory opinion in good faith, and the expectation is that when the advisory opinion is given, you will follow it. But we have unfortunate instances where that hasn't happened.
Okay. God willing, you find yourself in the same, you are appointed as the Chief Justice of the Republic of Kenya, and you find yourself in the same position as Maraga CJ in the matter of the 2/3 gender rule. How will you advise the President of the Republic of Kenya?
That is a live question, Judge. It's not a fair question, because it is an issue that is in court. There are people who are arguing that this shouldn't happen. I think we should say that Justice Maraga did his duty under Article 261(7), and the jury is still out. So we will see how this is finalized.
Okay. What is your gut solution to solve this problem of the 2/3 gender rule?
You know, when you ask me of a gut, I am a thinker.
Yes.
So I don't have a gut solution, because I know the 2/3 gender rule, if the first advisory given was that meet that 2/3 gender rule, it would have been met. But now we've opened up spaces for discussions, and those discussions are even now
how do you
being
meet
discussed.
that? How do you meet that? Give us solution. Today, sitting as Professor.
I cannot meet it. If I could and I had the power, I would have done it. Because you see, you need to deal with the processes that bring out leaders. So one of the ways in which this is done is through quotas. You give quotas. So you say that if you don't have enough persons to meet to ensure that the 2/3 gender rule is met, then you will top up. And this is what has been the case with the county assemblies under the Constitution. And I think also with the National Assembly, the provision for the 47 county women seats was also a measure. So affirmative action. And you see, my problem, I think, is that we get into affirmative action shabbily. We never say what is the the twilight of affirmative action. And I think we have missed the opportunity of defining how we deal with inequality. It's not just gender. Even when you talk about marginalized communities, you talk about persons with disability, because we don't have an equality law that tells us how to deal with bringing the people up, and how we deal with when we have attained. Because you see, you don't have affirmative action so that now women are the ones who are more than men. There has to be benchmarks and monitoring and evaluation.
Article 261 falls within the transitional and the consequential provisions of the Constitution. What do you think is the life of that provision?
I think the life of the provision would have been anticipated. It should have been not one that lasts forever, but it is there, and there was no twilight for it. So that, I think, is why Chief Justice Emeritus went to it. This is the 11th year of the Constitution, and it is still a provision in the Constitution.
Okay. Let's come to disobedience of court orders. What measures would you propose to ensure that all and sundry obey court orders and we are all subject to the rule of law? Radical measures. For example, will you keep a black book in your office to register anybody who disobeys court order?
You know, the issue of what you do with people who disobey court orders is really a vast one, because you see, once a decision is made and then you've given the orders, there will be parties that follow up the enforcement of those orders. I wouldn't have a black book, but I think as a Chief Justice, I would be concerned about these wanton disregard of court orders, because when you have too much disregard of court orders, then the lawlessness becomes the way in which people behave, and law is actually the exception to the rule. So I would actually talk to the different arms of government about all of us working in concert to ensure that the rule of law is abided by everybody, because failure to abide by the rule of law doesn't hurt just one institution, it hurts the whole country.
There is an issue of concern to the citizens of this republic, the issue of backlog, delayed judgments, lack of getting hearing dates. How do you intend to solve those problems?
I think one of the things now that we have, there is COVID-19, this for me is a silver lining, because if we ensured that the courts that hear matters virtually are able to produce the outcomes quickly. And you know, I'll give an example. When you use Teams or you use Zoom or even Blue Jeans or others, you can actually record. So now the issue of writing with the long hand is no longer as big a problem. So you can actually look at ways of downloading these recordings and putting and ensuring that decisions are made in a quick and expeditious way.
Okay, and lastly for me, Professor, what is your solution or proposal to resolve the dilemma of the 41 judges?
I would be talking to the President. You see, now as the head of the one arm of government, as the Chief Justice, I would approach the President to get this matter unstuck, because it is not a good thing that it has remained that way. And you see, even in getting it unstuck, he's also listening to what are these concerns, and because the decision has already been made, how do we ensure that we get these judges appointed.
Thank you very much, Professor. I wish you well. Thank you, Chair.
Thank you, Judge Wasame. Professor, we asked you for sample writings, you remember, and you submitted. So I'll request Commissioner Judge Majaja to take you through that.
Thank you, Chair. Good morning once again, Professor Senior Counsel. You submitted 5 writings, sample writings. Of course, being the professor and my teacher, it's, you're putting me in that situation where I have to engage with my teacher and professor on the sample writings. But I think your scholarship and writings are of very high standard and quality, and no one can dispute that. They exhibit interdisciplinary comparative approaches to issues dealing with contemporary legal problems. And also, it is, I must observe that some of the writings actually deal with the issues in the judiciary. But instead of going through them, I think I'll just follow up first from where my colleagues left. You have been in academia for very long, and one of the things that troubles those who have not had a retrospective or a reflection on where of the kind that I would expect from serious academic, serious institutions, that tells us where we are, where we have been, and where we are going. And I compare that really like for South Africa, where even on an annual basis you have serious scholarship on the jurisprudence of the Constitutional Court on various subjects. So as part of and this is in the Supreme Court strategic plan, this issue of knowledge management, enhanced jurisdiction, and creating partnerships. What is it that you bring to bridge this serious gap?
Thank you very much, Commissioner. I think it's a very serious indictment to say that we have not had academics query and interrogate issues. For me, I find writing therapeutic. So when something really disturbs me, I write about it. And I would say that maybe this is happening. People are writing about different judgments, but there is no cohesion and no organized way of doing it. What I will bring to this space is the fact that I have linkages with the academy. I mean, like I keep saying that the academy in Kenya is, I can't say that there's a problem with it without owning it. So if Commissioner Majaja says we are not doing good work, then what I have to do as Chief Justice, and I've thought actually about that, is to establish ways of following trends in jurisprudence. And that would go to the question that I think it was the Chief Justice that was asking, and also Commissioner Judge Walsame, this whole issue of jurisprudence. We need to begin tracking what are the trends. And it's not just at the Supreme Court. I think even in the Court of Appeal, even in the High Court, we need to utilize the Judicial Training Institute and partner with institutions or academic institutions to begin this introspective loop. And I think
Yes.
10 years is a good time.
Yes, thank you, and I look forward to that. And correct me if I'm wrong, in many of your writings, there's a writing there on constitutions as pathways to gender equality in plural legal contexts. You raise issues about the legal environment, the environment of legal pluralism that characterizes the Kenyan state, and this, I believe, has been a theme through your writing. You have the formal legal structures, and then you have the informal legal structures, the particularly Africa customary law, and other structures that support that system and the relationship between the two, particularly in issues of gender. What struck me, and again, give us an illustration of how this constitution we have can be used to transform what you to proceed with the decolonization project, for example.
I think in terms of the formal informal, if you look at the jurisdiction of the court, I mean the power of the court, there is also mention of alternative dispute resolution, traditional dispute resolution, alternative justice systems. Because of the fact that I've done a lot of work, especially on the ground with women, it is very difficult to say you can use the Constitution in this one way, because constitutions are pathways, because they will stop actions. You know, Constitution has power. So if you say, and this is the one I was talking about, the advisory on gender, if the Supreme Court had said you cannot have those elections if we will not meet the two-thirds gender, that would have been achieved. But when you're dealing with norms of customary law, which have, because you know they are not written, they are living and dynamic. So sometimes somebody is telling you about what the customary law is, and they are interpreting it as they go. It's the Constitution can help by, and I think the judiciary, by picking a number of spaces where these informal systems really are, and looking at how can we use the Constitution to actually bring it up. And if we don't do that, because 90% of disputes are solved outside the formal courts.
Yes, and we've made attempts, for example, to deal with some of the cultural problems we have, and a good example that has given a lot of debate. For example, I think it is accepted that having sexual intercourse with anybody under 18 is not something as a society we should condone, and that's why we have very strict defilement laws, and the criminal law system then moves very hard against that kind of behavior. On the other hand, you have domestic violence. Domestic violence very prevalent, and I'm sure even with this COVID we have begun to realize that it is a bigger problem. In 2015, Parliament enacted the Protection Against Domestic Violence Act, and I'm sure you recall it. A very simple, straightforward process. If you are involved in domestic violence and you don't have to be a wife or a spouse, it covers the children, it covers a myriad of situations, wider than what we think. But in my own research, I have not found any case where this statute has been invoked by anyone. How do you explain that kind of a situation, and how, as a Chief Justice who is concerned about the broader issues of justice, you'll be the head of NCAJ, how do we deal with those kind of issues?
Thank you very much. I think the issue of having a Protection Against Domestic Violence Act will go to the context in which the violence is occurring. And domestic violence occurs within the family. And you see, even international conventions, like the Convention on the Elimination of All Forms of Discrimination Against Women, shows that dealing with infractions that happen in the family is difficult. You know, the family is at one time protective, and then at the other point, it is where you suffer most. So you can actually have a law that even accessing it, I mean, the person leaves the family to go and access this law. Where will they go back? Because there is no shielding of the person from the fallout. So in essence, I think we need to work with other justice sector actors, both state and non-state, Because you see, like with COVID-19, when people talk about when you see the statistics, you panic. When it is not normal that girls who should be pregnant taking exams, but it has presented. And it may be domestic violence, maybe not domestic violence. So how do we deal with the societal issues?
Okay.
Yeah.
Thank you. Now, going back to the court and following up from what my colleague, the Deputy Chief Justice, talked about, and you answered, you said that you are a very dominant person. And I'm sure dominant, by the way, justified because of your intellectual heft. One of the criticisms of, whether it's right or wrong, I don't know, that the Supreme Court has faced is that we do not, they write a single judgment. You've heard of that criticism?
Yes, yes.
We are not able to gauge the intellectual position, ideological position of each individual judge and what we bring to your table. And one of the fears is we have you, professor, coming in, going to that court and being absorbed in the ship mentality of writing joint judgments. How can you talk about that?
Thank you very much. I think when I was answering the question by the Chief Justice, I said that I will encourage judges to use their mind and pen to put out what would be what they are finding. And that I think is the approach that was taken by the first constitutional court in South Africa, that even if you are agreeing, let us see you are agreeing on what basis. And I think it's a very harsh judgment that you're saying ship mentality.
No, I'm just giving, you see, I'm putting to you what the critics say.
Yeah.
Yes.
But you see, I will be the Chief Justice.
Yes. So now you are reacting to that criticism.
So as the Chief Justice, I will encourage individual judges to put their mind and pen to paper. And because I will be Chief Justice, I don't expect that I will be the one writing. I will write my bit, but we will have other people working on the collective decision.
And what are the advantages of having a joint decision as opposed to separate opinions? And what are the circumstances where you decide, okay, this one, I'm the Chief Justice, it is important for us to write one decision? Can you just tell us that dynamic? Because you'll be going to that court.
I think the dynamic of writing one decision sort of denies people the opportunity to know what is in the mind of these other judges. And you see, that is where when you say that a person is dominant, you may have that one dominant worldview. When people write individual decisions, you're able to tell what is their jurisprudential and judicial philosophy. And I think for new courts, many times, many of those senior courts, they encourage having a joint decision. But I think it does deny the country the intellect. I mean, these are how many men and women? They are the top grey matter. We need to know what is it that they think.
Okay. Now, going now back to the issue of jurisprudence, to the issue of jurisdiction. I think jurisdiction is what determines what the court will do. You agree with me? And my colleague, Commissioner Wasame, talked about this jurisdiction that keeps expanding and narrowing, what Professor Ode called the hourglass. Yes, hourglass jurisdiction. First and foremost, there's this issue of election petitions, appeals from election petitions. And in the first cases that came to the Supreme Court, the justification for taking this jurisdiction was based on the normative derivative theory. Can you explain that to us and tell us whether it is actually justified as a means of appropriating jurisdiction by the court?
I think when you're talking about normative derivative, you're looking at the fact that the Supreme Court has the mandate to look into constitutional issues. But you know, if you look at many of the things that arise, they will touch on the Constitution, some directly, others peripherally. And my view is that there are many laws, like in elections, there is the elections law, and we should aspire to end issues as much as possible there, unless there is what I think in Hermana's case is a matter of public importance, which then would justify
the issue should not be whether it is actually a petition, but whether it raises a matter of general public importance.
Because you know, when you go to election, nobody believes they will lose, and because they are time bound, it is important to have the parties finalize their issues without having to go to the Supreme Court. Because I think the opening up of jurisdiction at the Supreme Court level opens the court also to all manner of accusations.
Yes, and that is why the proposed amendment talks about a determination of the Court of Appeal in election petition shall be final, isn't it?
Yeah.
That's what it talks about. But even when it says it is final, is there a pathway of that finality to the Supreme Court? Even where the Constitution says it is final. Say, for example, in an election petition, the court interprets certain provisions of the Constitution. Do you think there is a bypass mechanism to that kind of a clause?
I don't think there is a bypass mechanism, because cases should come to an end, especially when we are saying they are time bound. So when you begin to bypass, then it means that you're also opening up how much more time is used. That is, I think, ending the matters at the Court of Appeal would sort a lot of the issues that we're dealing with.
Okay. Now, you have done a lot of environmental law, and I'm sure you're one of the people who praised the Mitubel decision. I'm sure you're familiar with it. The Mitubel decision was about public land, primarily people occupying public land. But there's a bigger issue in Kenya. It's not so much about people occupying public land, but people occupying private land despite the proprietor. And for example, if you go to Mombasa, Malindi, that is adverse possession is the largest component of the cases. In your view, how does adverse possession, the doctrine of adverse possession, how does it relate to the issue of access to land by those who are dispossessed?
The doctrine of adverse possession is, it holds that if a person occupies the land of another without secrecy, there are three without.
Yes.
Then after the 12th year, then the person can actually move for adverse possession of that land.
It's a prescriptive right.
It's a prescriptive right, and I think it is informed also by, by the fact that if you have not used this land for 12 years, then it could be that you had abandoned. You know, it's really common law. It's a common law equity issue. Now, in our country, we have we have the preponderance of people on either public or private land. And sometimes you may even attempt to get them off, and you can't get them off, because also, you know, if you're getting them off and you're not getting in, because to deal without secrecy, I know that some people just you scare the people away so that you can break the 12 years. I think it's Mitubel for me is a difficult decision from the Supreme Court. This whole issue of the rights that these people who are occupying the land have. And this is because, you see, it is not a prescriptive right that they have got. They have a use right, that
Yes.
as I understood.
I just want us to go to the doctrine of reason possession. It is very much entrenched in our law. You agree with me?
Yes.
It is very much entrenched. We have established principles. And in fact, you've read the decisions of the Court of Appeal saying it does not violate Article 40. Those decisions. So I just want to read for you something in the Mitubel decision, and you will let me know what this means. Eh? This is what the Supreme Court said at paragraph 151 of that judgment. While we are in agreement with the submissions to the effect that an illegal occupation of private land cannot create prescriptive rights over land in favor of the occupants, we don't think that the same can be said of an illegal occupation of public land. To the contrary, we are of the considered opinion that where their landless occupy public land and establish their homes thereon, they acquire not title to that land, but to a protectable rights to housing over the same. And really that was the issue, isn't it? That
Yes.
if you are on public land, there is something the Constitution protects. Now, in that sentence, do you perceive that the Supreme Court was actually saying that they cannot be prescriptive rights over land?
I have grappled with that issue because, you know, prescriptive rights actually apply to private rights to
Yes.
land. And this distinction between private land and public land has actually been disturbing to myself. And I think that is something that we really need to look at.
Yes.
Uh,
So I just want to try and tie up this issue. Now you are a judge, and this goes to your judgment writing. It goes to the way the dispute resolved. Do you think, as a judge seated in this case, you would have made that particular sentence, because now it has left in a lot of doubt? What about those of us who sit in the High Court?
You know, I'm sure that is not the last we are hearing of this matter. And because I have not read and canvassed all the things that I know about prescriptive rights, I'd like not to pronounce myself on that issue just now.
Okay.
But it is a problematic issue.
Is a problematic issue. Okay. Now, you taught us a lot of evidence. You were my teacher in evidence. We used to call you the evidence. The case that reached the Court of Appeal on the issue of evidence, the Iranians.
No, I'm not.
Okay. Okay, that's I'll leave that. Going into another subject, and this it's about case management. You talked about being involved in JP creating the performance indicators, and one of the things we have battled with is dealing with qualitative indicators, because people say, okay, you are now churning out the judgments, you're actually clearing cases, but we are concerned about the quality. We are concerned about the quality. What are some of the issues, and particularly since you are from academia, in terms of creating a framework for looking at the quality of decision making throughout the judiciary. Can you give us what your thinking would be? Because that is something now we want to move towards, not just the quantity, because we have done a lot of backlog. Now we want to say, okay, now with these cases we are remaining with, we want to see some quality. What is your perspective on that?
I think when we were looking at what are the trends in jurisprudence, we would need to see those trends. But I would see training as a big aspect of this qualitative and inculcation of a culture of looking out. And I know that judicial officers have researchers just looking at what is it that we are saying, what have others said, because that helps us to come with more quality judgment.
Okay. Just on the issue of training, part of the criticism we face, and even as a Judicial Service Commission we have to deal with, is the sentiment that, you know, judges, you are employed to, magistrates, you are employed to come and decide cases. You should not be doing training, because training is a waste of time. It takes up judicial time. What is your perspective on that, and how would you answer the public?
To say that judges don't need training is actually setting them up for failure, because nobody was born, or not even a professor like myself, nobody knows all the laws. So the role of continuing judicial education is, first of all, when you, even if you are a judge of say the High Court and you became a Justice of the Supreme Court, that you need to learn the culture. So induction is very critical. And then looking at areas of law that have come up. I think what we need to think about is innovative ways of making training not remove judges from what the public wants to see. And you see, what you can do is structure training rather than saying this week we are training. You know, you can have a training program that goes on for a month. A lot of the online training programs, so you say each week you do 3 hours. And so you meet the expectations of the public, but you also train the judges.
Okay. And finally on that subject, this COVID season has taught us a lot about how to conduct cases. But one of the things we are learning and we have to deal with, in fact, going forward, and just talking about our performance indicators have been affected negatively by COVID. So there is a way in which technology is a barrier of access to justice in many ways. And that is something that has to exercise the mind of the Chief Justice. How would you look into and resolve this particular issue, given the fact that the judiciary is a service institution?
I think we shouldn't make justice inaccessible through technology. But having said that, it is important to use technology as much as we can to bring justice closer to the people. We were dealing with that exact issue with teaching online, because teaching in a public university, you're saying, how do you reach the last mile? You know that this Kenya is among the African countries that have very developed ICT infrastructure. And in fact, we are not called Silicon Savannah for nothing. So what I would look at is, what is the last mile and how can we meet that mile? And we can actually partner with organizations like the Communications Authority. They have Universal Service Access Funds. We see how we can access those. And also with the Ministry of ICT, to ensure that we take technology to the people. If everybody has a mobile phone, you know, in Kenya, I think the mobile phone penetration
are more personal. Have you been engaged in the BBI process?
Can you define engaged?
Engaged in what way? What is your relationship either with the committee? Have you engaged with it?
You know, I was not involved in BBI at all. And the reason that I got into BBI was actually it's an interesting issue. And I was out in the village and somebody called me, said they are looking for a scholar to read this document and present it to Kenyans. And I asked, why wouldn't it be presented by the ones who wrote it? And I don't know why they couldn't pick on one of them. Your guess is as good as mine. So I actually agreed to go and read the BBI. I had a turnaround of 24 hours with a colleague and presented it. And even before Kenyans, I said, I did not write this document. I have engaged in the BBI in looking at how it affects certain constitutional provisions as a scholar. And I am currently advising Parliament on the proposed amendments. But that, again, is something that is alive before the court and we're working on.
Yes, because one of the things you will be required to address when you are Chief Justice, or if you are Chief Justice, is the concern raised by the constituency I represent, that is the judges and magistrates, and this commission, about the amendments affecting the work of the commission in terms of bringing in the ombudsperson and the manner of determining complaints. So in your first speech coming in, how would you reassure the public and the Kenyans that you are the person that, one, this process, if it comes to fruition, will protect the independence of the judiciary, and you are the person qualified to protect the independence of the judiciary?
And you know, again, we go back to the twin issues of independence, accountability. You know, many times we approach things, and even me as a scholar, sometimes I have that tendency. You approach it without looking at it and seeing what does it really mean. If you look at the concerns about judicial independence and accountability historically, the Constitution went into a lot of efforts to ensure that these were put in the Constitution. And I think we have achieved a lot in independence, and we've moved some way in accountability. The many mechanisms that are within the judiciary for accountability. But the only I'd like to pose the question, what is the mechanism for Wanjiko to know how accountable the judiciary is? As it is now, is the State of the Judiciary Address Report. And is that accessible to Wanjiko? So, in changing or in seeking to re-engineer the office of the Judiciary Ombudsperson, I think as a judiciary also we need to go to it with openness. Because if we are saying that the problem is that the appointment is X, around this table, which is also an institution that was established for bringing about accountability, there are a number of people appointed by that authority. And I think for me what I'd say is what we want to do is to get support from the public. And you know, when you talk about accountability, answerability to the people, anything that can make us more answerable, I think is a good thing. And I think we shouldn't go to it. Remember we talked about interbranch relations. If interbranch relations are good, then we won't be looking at it as another way of flowing into judicial independence. So
you believe it's a good thing for the judiciary?
I think it's a good thing. Yeah.
Thank
because you see, a lot was done inside. But who knows about PMMU outside there? Does Wanjiko know?
So is it the issue that this Judicial Service Commission has failed to communicate what it has done, such that we need somebody else to come and take over the issue of transparency, accountability, to be able to assist the judiciary rather than the Judicial Service Commission?
I would imagine in establishing the office of the Judiciary Ombudsperson, there would be a lot of work with the JSC. All I'm saying is that we shouldn't look at this thing in silos. We should look at what can be achieved.
You know, we should look at what can be achieved, but you know, this country has a long history, and the Judicial Service Commission, being where it is now, is a product of that history. And all we are saying is that you, as the Chief Justice, on your first day, you have to come and assure the judges, the magistrates, and the public who are concerned that in fact this person who is coming in to do, and if you look at the objectives, both JSC and Ombudsperson, who by the way you will have no control over, are doing parallel, have the same objective, doing parallel work, answerable to different institutions.
I think what I would talk about is ensuring that it is not a mechanism of looking into the judiciary from outside, that it works from within the judiciary. Like I said, if we just being appointed doesn't mean that you work alone. I don't think there is it has been elaborated, but I stand guided. I'd stand guided if the judges think that this is. So I'll think more about it. But how I had thought about it is, it's not really such a big deal.
Thank you very much, and wish you all the best.
Thank you very much. I now would like to request Commissioner Jeru to go on, and then after that you have a short break.
Thank you, Prof. And my senior. Let us start with the jurisprudence. And I looked at your sample writings, and that's where I'll ask you a few questions on your legal philosophy and how you tackle jurisprudence at the Supreme Court. Now, there's this peer-reviewed article you did with the Oslo Law Review. Now, and you are discussing the issue of how to use the laws to realize gender equality. And what I noted is that you say that in rooting for an appreciation of the role and place of legal pluralism in promoting gender equality, the paper contends that formal laws in and of themselves are not enough to effectively deal with gender discrimination, effectively saying that they must also take into consideration our customary law and practices. And in fact, I noted that what you said is that sometimes, even when we think, even judges, when they think that you know, that they are applying the formal law, inwardly probably sometimes they are also you know, influenced by the customary law and practices, and they use now the formal law as the argument in enforcing certain decisions, but in actual fact, you know, they are also prejudiced by the you know, the customary law and norms. I don't know now, the reason why I'm asking you this is if you are to get now into the Supreme Court, how would you go about in ensuring this principle of ensuring that even as you're looking at the formal laws, you're also taking into consideration the customary law practices that are deeply ingrained within our society?
Many of these issues would come when they have been litigated at the lower levels, and I see the Supreme Court's role here as giving life to the fact that we have a juristic legal pluralism, where our constitution saw it fit to allow among the sources of law, custom, religion, international law, and statutes, etc. So I would think that an issue coming up which has nuggets of customary law that have not been dealt with would actually be something that the Supreme
of a patriarchal nature, sometimes even judges themselves could be influenced in a way that as they, make decisions, that particular you take to ensure that if you are talking about equality, we are talking about equality even in the decision-making process, and ultimately how, it's interpreted, how the law is interpreted.
I think you've really hit the real issue, because when you talk about equality in a patriarchal society, people begin to interpret equality as how they know it. And there is one course that I have taught for many years, and it surprised me how when people talk about gender, they feel very happy just rehashing prejudices that they picked along the streets, and those are supposed to be what is the law. So in essence, we need our law on equality is in the Constitution, but we have not brought it down to a statute that, in my view, needs to rank inequalities, so that we know are all inequalities equal, and which is the 2 or 3 inequalities that if we hit, we will hit others. So there is a work for the legislature, but I think should the matter come to the Supreme Court, it will be something that one can help in thinking through.
Yeah, but I would, probably I'm also prejudiced because I'm a child of a single mother who saw my mother suffering that consequence, where the law is actually working against her, when it comes to the issues of this, distribution of the property. So I'm interested because it has taken too long, We are here many years later. There is the law and all that, but even when it comes to the interpretation of the law, you still find that it's so tilted heavily, against women in favor of men, because of our the patriarchal nature of our society. That's why I'm asking, so that it doesn't just become a moot point where it's talked about in papers and all that, but if you are to be seated in that court, what are these clear steps, knowing of course that you are one amongst many, but at the end of the day, as the head of the institution who will be the leader of even development of jurisprudence, what are the active steps? If you could just analyze for me, say like 3 active steps that we take in ensuring that we are no longer talking, but we are making it a reality.
Because the court is going to be working on things that are brought to it. If the issue is brought to the court, I would actually be encourage us to not just decide it from a gut feeling, but to actually think through the that law doesn't provide. It is just that people interpret law in a way that removes certain people from being actors. So I would encourage us to learn. I think many people don't really understand equality and gender. And that, I think, for me, education.
Okay. Now, arising from what you've just said, because where you say that, unless a matter is brought to you, recently there was a situation that arose similar to what you've said, that you'd have to deal with the matter unless, you not deal with the matter unless it's brought to you, in the Supreme Court of United States, where there is this case of Transworld Airlines versus Madison in 1977 that provided that employers must take into consideration the religious needs of their employees in work environment, but subject to it not causing undue hardship to the employer. Now, that was 1977, but the Congress did not had not defined what is undue hardship. And the precedent has been existing now for 44 years. But now recently in the Supreme Court, two judges, Neil Gorsuch and Samuel Alito, decide that there's a matter where we have an opportunity of probably changing that precedent and defining undue hardship, expanding the scope of an, in a way that the religious needs of the employees are actually taken into consideration. But the other judges say that unless you have a matter that is brought before us in, the way you are saying, we have a clear opportunity, we can't even, touch that matter. And so the two judges, what do? They decide to go public with a dissent, what would basically be judicial activism. So what is the place of judicial activism in a situation where you want to redress what you'd call certain prejudices that have worked against certain parts of the society?
I am happy to hear about judicial activism must be within the confines of it is not unimaginable that somebody is just going to also bring an issue, but I would need, of course,
again from on how the courts could declare certain acts of legislature and the executive unconstitutional. Now, which is a problem that again we've had here, in our country, where laws and judiciary, what steps you take to ensure that, firstly, of course, unconstitutional laws are declared as such by the court, but again, there's also no judicial overreach to a point where it brings unnecessary friction. The balancing, I'm not sure what would be your thoughts around that as the leader of the institution in the development of the jurisprudence.
I think, okay, many times judicial activism, people talk about judicial restraint. But you see, the line is very thin, because you can become so restrained that your hands are always tied. But I think we need as a together, because you see, if the law is unconstitutional, it is unconstitutional, and if it has been brought as such, and I think courts have done that, it is also reaching out to see how can we, in making our decision, help the legislature. And I think, like, when they give, they say they will be operative for a particular time within which you must have regularized. So you see, that is a way of sort of balance.
Because my constituency, the lawyers are generally also always concerned about the running of the institution of the judiciary itself, because it affects them directly. Now, I was wondering, there's a question that you asked about, you know, the ability to run the institution as the CJ if you came in, considering that you've not practiced and you've also not been, I mean, as an advocate in the courtroom. And or as a judge. Lee Kuan Yew, the then Prime Minister, thought it was not running right. He felt that the judges inside, one